Hello, viewers. Welcome to another lesson. In today's lesson, we shall be looking out for answers to the question why the Creoles and other persons can't own land in the provinces. And this lesson has four objectives. Firstly, I want you to know the meaning of native and non native. Secondly, I want you to know the historic description of the two sects. Thirdly, I want you to understand the land rights enjoyable by both parties. And lastly, to know the exceptions to the land rights. Now, to the meaning of native and non native. A native has been defined as a person who is a member of a race, tribe, or community settled in Sierra Leone or the territories adjacent thereto. In other words, if you are a member of the Limba tribe, the Mende tribe, or the Timni tribe, it means you are a native. Or if you are a member of the Shabu tribe from Bonth, for instance, which is a territory adjacent to Sierra Leone, then you are a native. Now, a non native is a person which is of European or Asiatic origin, or whose principal place of settlement is in the colony. So, in other words, if you are from Europe or Asia, or if you are a descendant of those who settled in Sierra Leone from England upon the abolition of the transatlantic slave trade, for instance, the Creoles, then you belong to the group of non natives. Now, to the historic description, to the history as to the description of natives and non natives. Now, a short history has been accounted by Barbara Harrell Bond, and it narrates as follows. By the turn of the century, more than half of the population of the colony was from the hinterland, and these Africans were transferred by both the British and settlers as Aborigines. They were referred to as Aborigines, and at but around 1890, the nomenclature changed. The settlers became known as Sierra Leoneans, and the indigenes populated were called the natives. The Aborigines branch of the Colonial Secretariat in Sierra Leone has renamed the Native Affairs Department in 1891. The 1905 legislation, however, acknowledged this cultural dimension by providing a legal instrument which enabled an individual to change his identity from native to non-native. In other words, though there was a legal distinction between these two sects of persons, provision was, however, made for one to switch from one sect to another through the 1905 legislation. Now, to the land rights. Land rights such as leasehold and freehold are important to be discussed as to those who are capable of acquiring it. Now, to leasehold, non-native shall acquire a greater interest in land in the protectorate than a tenancy for a term of 50 years. In other words, if you are a Creole or if you are a European or if you are an Asian, you can't own land in the provinces more than a lease term period of 50 years. And if you wish to do so, such an extension should not exceed 20 years. Now, to freehold estate or interest in land, it is true, of course, that in strict terms of law, the freehold tenure of land cannot be transferred or transmitted in the provinces. So, in other words, land cannot be held absolutely in the provinces. However, leasehold is applicable in the provinces, and the freehold is only applicable by the general law only in the colony, that is in modern day Freetown. So in Freetown, you can acquire land absolutely, granting you the right to even sell and transfer to your kids, unlike in provinces. However, this leasehold interest in the provinces has limitations through the landlord principle of overreaching interest. This overreaching interest is the process by which the rights of beneficiaries under a trust of land become detached from land on conveyance and attached to the proceeds of sale. In other words, if though land is held in trust by paramount chiefs in the provinces for the benefit of community members, that benefit or interest community members have in that land held in trust can be overreached and entirely terminated for a long period of time without them later claiming it. And this is done through consent. If having gone through the lease agreement or the paperwork agreement to acquire land in the provinces, but consent to overreach by paying money, that is proceeds of the sale, by giving that money to the beneficiaries who later on consent to terminate their legal rights in that land means overreaching their interest. And it is a limitation to the leasehold interest in land in the provinces. Thank you for listening. Thank you for watching. Please like, subscribe, drop your comment. I'll be right back next time.